Good day everyone. We will be talking about the Article 146, Illegal Assemblies. The penalty of prison correctional in its maximum period to prison mayor in its medium period shall be imposed upon the organizers or leaders of any meeting attended by armed persons for the purpose of committing any of the crimes punishable under this code, or of any meeting in which the audience is incited to the commission of the crime of treason, rebellion or insurrection, sedition or assault upon a person in authority or his agents. Persons merely present at such meeting shall suffer the penalty of arresto mayor unless they are armed, in which case the penalty shall be prison correctional. If any person present at the meeting carries an unlicensed firearm, it shall be presumed that the purpose of the said meeting, in so far as he is concerned, is to commit acts punishable under this code, and he shall be considered a leader or organizer of the meeting within the purview of the preceding paragraph. Take note that under Article 146, a meeting includes a gathering or a group, whether in a fixed place or moving. There are two forms of illegal assemblies defined under Article 146. The first form is any meeting attended by armed persons for the purpose of committing any of the crimes punishable under the code. The second form is any meeting in which the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion or insurrection, sedition or assault upon a person in authority or his agents. Below are the requisites of the two forms. For the first form, that there is a meeting, a gathering or group of persons, whether in a fixed place or moving, that the meeting is attended by armed persons, and that the purpose of the meeting is to commit any of the crimes punishable under the code. For the second form, the requisites are that there is a meeting, a gathering or group of persons, whether in a fixed place or moving, and that the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion or insurrection, sedition or direct assault. Both first and second forms include meeting, a gathering or group of persons, whether in a fixed place or moving. As to their differences, the first form requires armed persons, while the second form, persons whether armed or not. In the first form, it was specified the crimes punishable under this code, while in the second form, crimes such as treason, rebellion or insurrection, sedition or direct assault were mentioned. To better understand the provisions of Article 146, let's take a look at this sample situation. There was a meeting, and there were 24 unarmed persons, and their purpose was to commit theft. What crime is committed by 24 unarmed persons who gather together in a meeting for the purpose of committing theft? Actually, they do not commit any crime. Take note that the persons present at the meeting must be armed to constitute the first form of illegal assembly. Let's try to change some facts of the sample situation. Suppose 4 of the 24 persons were unarmed, and their purpose was to commit robbery. Must the meeting be considered an illegal assembly? The answer is yes, because the law does not state how many of the persons attending the meeting must be armed. It is said that a good number, say at least 4, must be armed. Unarmed persons present at the meeting of the first form of illegal assembly are also liable. For unarmed persons, the penalty is arresto mayor. For armed persons, the penalty is prison correctional. Who are liable for illegal assembly? These are the organizers or leaders of the meeting and the persons merely present at the meeting. As illegal assembly is a felony, the persons merely present at the meeting must have a common intent to commit the felony of illegal assembly. The absence of such intent may exempt the person present from criminal liability. Thus, if a person happens to be present at an illegal assembly, out of curiosity, he is not liable. When a person is present at the meeting carries an unlicensed firearm, it is presumed that the purpose of the meeting, insofar as he is concerned, is to commit acts punishable under the code. He is also considered a leader or organizer of the meeting. Let's try to apply the requisites of Article 146. U.S. versus Vergara. Are the requisites under Article 146 or the second form of illegal assembly present in this case? The defendants were tried upon an information charging them with the crime of rebellion. The evidence showed that they had organized a Katipunan society, were against the government, but failed to disclose any overt acts. The defendants attempted to prove that they were organizing a new independent Filipino church known as the Aglipayan Church. This latter fact, in the judgment of the court, was not established. Going back to the issue whether or not the requisites are present, yes, several witnesses testified that the defendants organized the Katipunan Society, and the purpose of the said organization was against the government. The evidence further showed that the defendants solicited various persons to become members of the said organization. Here is a table showing the requisites and the application in the case. Both requisites are present in the case. The evidence showed that the Katipunan Society held various meetings in the houses of Manuel Ruiz and Manuel Sandico. Several witnesses said that the defendants organized the Katipunan Society and that it was against the government. That's all. Thank you so much for listening. Have a good day.